Are y'all ready? Yes, sir. Okay. Good morning, everyone. The time is 9 o'clock. I hereby call this Citrus County Code Compliance hearing to order for Wednesday, February 18th, 2026. For these hearings, we typically follow an agenda. The first item on the agenda was the call to order. We just had that. The second item on the agenda is the pledge to the flag. So I'd like to ask you to join me as you are able for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay, the next item on the agenda is approving the minutes from the December hearing. We skipped the January hearing because I wasn't going to be available. I have reviewed a copy of the minutes because it was emailed to me, but I don't have a copy here. Are there any proposed modifications, changes, deletions to the minutes as currently formulated? No. Okay, then I'll go ahead and approve the minutes and I'll sign them if y'all have a copy, or I can print one out at the office and deliver it to you. Staff update?
Staff update, no updates at this time. Thank you.
All right. Good morning, everyone. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over this hearing. What I'm going to tell you during this broad opening statement applies to all of your cases, so I'd like to ask for your close attention. When your case is called, please come forward. You will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call the case, and I will allow the county to first present its case. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. I will ask whether or not you are contesting the violation. If you do not contest the violation, I'll assume that a factual basis exists for the violation and ask you how much time you need to fix it or to work with the county. This will help save time for yourself and others, but you are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, those members of the public will have an opportunity to speak, one per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty, the law requires that you be given a time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property. This county has a right to foreclose on that lien or to seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. There are also instances in which the county will ask me to find whether there has been irreparable harm and ask for a one-time fine. I may do that as well. If it is a one-time fine, it's something that will just be assessed and there won't be an opportunity to correct. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you'll be responsible for additional costs, as well as the cost of the lien imposed. Although it's only happened a few times, I may continue your case if I find the need for further evidence or argument. Another thing to keep in mind about potential settlements, if you agree that there is a violation and you decide with the county to come to a resolution, then it probably will be better than whatever I assess. So it may be in your interest to come to that resolution. You do have the right to appeal any order that I make today, as may be provided by law. Thank you.
First case on the agenda is a no contest. Property owner Richard Barrington, Anthony, and Rosemar Reyes. Case number CE 2025-02076. Code Officer Julie Wilkinson, page 6 of your agenda.
Okay. Yeah, why don't you come up, sir? I'll need to ask you a question or two.
While he's approaching, I was notified that this was a no contest with 30 days to cure and $50 a day thereafter if not brought into compliance.
Okay.
Yes, yes.
Yes.
Richard Anthony Barrington?
Okay, thank you, sir. You heard the terms of the proposed resolution. In other words, you'd have 30 days to abate the violation and then $50 a day after that, if you don't bring it into compliance.
Correct.
Okay, and you agree with that?
Yes.
All right, can you just tell me a little bit?
This case was for an overgrown lawn. There are weeds that were in excess of 18 inches.
Okay.
Most of the yard has been cut down. There's just a small piece.
Sounds like that can be done in 30 days, so
Yes.
I will accept the resolution. I'll ask if there are any members of the public who want to speak on this case. All right, then I'll order $30 a day to abate the violation. We'll
30 days, $50 a day.
I'm sorry, 30 days, 30 days to fix the violation, and then $50 a day if not brought into compliance as
We
ordered.
would take care of it today, but cool.
Thank you. Good luck.
All good? Do I
Yep.
need to do anything else?
You're dismissed.
Okay.
Next case is a no contest as well. Property owner Deborah Buell, case number CE 2025-02266. Code Officer Alan Jonason, page 9 of your agenda.
And while Ms. Buell is approaching, I was notified this is a no contest with 14 days to cure and $50 a day thereafter if not brought into compliance.
Okay.
Yes.
I do.
Deborah Jean Buell.
Dustin Allen Wonder.
All right, thank you. So the terms of the resolution I heard are 14 days to bring the property into compliance, and if it's not brought into compliance in 14 days, it'd be $50 a day fine. Is that right?
Yes.
Okay. What's your understanding?
Yes, sir. This is a lawn case. I've spoken to both of them, and they agree they're going to take care of it this weekend.
Usually
or
14
so.
days is a reasonable time
Absolutely.
period to get something like that
Absolutely.
resolved, so.
Yes, sir.
Are there any members of the public who want to be heard on this case? I don't see any, so I'll accept the terms. I'll issue an order saying that there's a violation. You have 14 days to bring it into compliance, and it'd be a $50 a day of fine after that. All right, thanks for your time. Good luck.
Thank you so much.
Next case is a no contest. John Campbell, case number CE 2025-2175. Code Officer Robert DeNaro, page 10 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
And while the parties are approaching, Your Honor, I was notified this is a no contest since it is a site modification case. The county was in agreement with a one-time fine of $2,500.
Could you raise your?
I do.
I do.
John Campbell.
Good morning, Mr. Campbell.
Morning.
All right, so what I've heard is that the resolution is, we can see there's a violation on the property. There's been development without a site plan, essentially, and you've agreed to a one-time fine of $2,500, and I think my authority goes up to $10,000? $15,000. $2,500 is as low as the county goes, so I think that in terms of their recommendations to me, believe it or not. So are the terms the ones that you've agreed to?
Yes. I mean, if I can speak, I did hire a company to do minimal clearing for an SFD, but the permit's been filed, it's been reviewed, and we're in the process of clearing.
And that's
those
good,
issues.
and I think that's why the county's probably recommending as low a
Yeah.
fine, even though it doesn't seem like it's that, that's generous from the county's perspective. The $50 a day that you hear is as low as the county goes on
Yes,
those
sir.
cases. Can you tell me a little bit about what the violation is?
Basically, like Mr. Campbell stated, that he had cleared some trees, he cleared, graded, cut to start the development of his home.
Just for the viewers on YouTube and members of the public, I mean, the issue with it and the reason why these cases resolve this way is because the county has an interest in making sure ahead of time that the proper permits are issued, that the site review is done, because there could be environmental concerns from site clearing without a permit. And it's not that anyone has bad intentions when this happens, but a lot of times contractors aren't giving the right advice. And you may have claims against the contractor. But at any event, I encourage you to seek legal counsel. Is there anyone from the public who wants to be heard on this case? All right. Mr. Campbell, I'm sorry this has happened to you. I am going to find that there's a violation. I'll assess a one-time fine of $2,500, and that'll be it.
Thank you.
Okay,
Thank
good
you.
luck.
Next two cases are no contest as well. Bert M. Dunn, case number CE 2025-2100 and CE 2025-2112. Code Officer Erica Olson, page 18 and 17 of your agenda.
Your Honor, I've been notified that these are no contest. We have the same agreement for both cases. So 4 months to bring them into compliance and $50 a day thereafter to, if it's not brought into compliance.
I do.
Bert M. Dunn.
Good morning, sir.
Good morning.
Let me just take a look at these cases real quick. Okay, that's an interesting resolution for both of them. In other words, so it's 4 months. Actually, Ms. Olson, can you just tell me a little bit about the cases?
Yes, sir. So this is a pretty large piece of property. Mr. Dunn has already taken quite a bit off the property. That's why I agreed to 4 months to get everything removed. As far as the RV goes, I don't believe
Yeah,
there's
and
like
I don't have any issue with that on
Okay.
what I call the junk case.
Okay, it's the RV.
I'm kind of curious about on the temporary occupancy case.
I don't believe he's dumping waste onto the ground. I think he's taking care of it how it's supposed to be. I think a lot of the junk is from them living in the RV. So I think once the RV is removed, a lot of the junk will be resolved as well.
So this is kind of just in the interest of it's giving enough time to make sure that everything kind of goes at the same time.
Yes, sir.
And there's, I guess, probably a hardship of doing
Yes,
it
sir.
any sooner.
Yes.
Okay. Are there any members of the public who want to be heard on this case? Mr. Dunn, are these the terms that you've agreed to?
I have.
All right. Then I will find a violation in each case. In case number 25-2112, which I call the temporary occupancy case, I'll find that there's a violation, grant you 4 months to bring the property into compliance. If it's not brought into compliance as ordered, $50 a day. Similarly, on case number 25-2100, I will find a violation. I call it the junk case. I will also give 4 months to bring the property into compliance. And if it's not brought into compliance, $50 a day fine. Good luck, sir.
Thank you.
Next two cases are no contest as well. George J. and Nancy O'Brien, case numbers CE 2025-1886 and CE 2025-1857, pages 24 and 25 of your agenda. Expert on the case, Land Development Director for case 1857.
I do.
Nancy O'Brien.
Charles Loftus.
Okay, good morning.
They got up here pretty quick.
Yeah.
I've been notified that as a no contest case, Your Honor, the parties have agreed to 14 days to cure both cases and $50 a day thereafter if not brought into compliance.
Okay, so, all right. So I see the cases. Ms. O'Brien, does that comport what you just heard with your understanding of the resolution? Is that a yes?
Yes.
I just need it on the record. No, fair enough. Are there members of the public who want to be heard on either of these cases? I don't see anyone. Mr. McGuire, can you tell me a little bit?
Yes, sir. So this is a junkyard case and a RV case. I was in contact with Ms. O'Brien Throughout the beginning of it, I lost contact, and then till this morning.
Okay. All right, I haven't heard any concerns expressed. It seems reasonable to me. So what I'll do is in case number 25-1886, I'll find that there is a violation, but grant 14 days to bring the property into compliance. This is what I call the junk case. And if it's not brought into compliance as ordered, there'll be a fine of $50 a day, okay? And then there is what I call the temporary occupancy case, which is case number 25-1857. I will similarly grant 14 days to bring the property into compliance. And if that isn't brought into compliance in 14 days, it will also have a $50 a day fine. I will just tell people this is clearly a bargain sale from code compliance right now at $50 a day fines. So I think it's a good deal for you.
Do I have to call him?
call you,
to
ma'am.
tell
So
him?
I'll issue a written order, but please stay in touch with the county and let them know when you've done the job. All right?
You can do that.
Thank you very much.
Thank you.
That's it for the cases that are no contest.
Really? That's
Yes,
it?
sir.
Okay.
Next case, Dwight O. and Anita E. Broussard, case number CE 2025-02113, Code Officer Cody McGuire, page 8 of your agenda. Expert on the case, Land Development Director Joanna Katu.
I do. Dwight Broussard.
Good morning.
Anita Broussard.
Good morning. All right. I'll let the county proceed.
All right. Cody McGuire, Citrus County Code Compliance Officer, case number 2025-2113, Land Development Code, Section 3102E, Special Requirements for Accessory Structures. The address is 4485 North Elm Drive, Crystal River, Florida, 4.94 acres, and it's zoned RURMH. The property owners are Dwight O. and Anita E. Broussard. Good service via signed certified member receipt and posting at the Canton Government Building. And then I'd like to authenticate the following documents and request to be admitted in evidence. Photos I taken during my initial inspection on November 25th, 2025. Photos during a corrective action inspection on December 10th, 2025. And photos on my final inspection conducted on February 16th, 2026. And then aerial photos dated June 20th, 2025 from the property appraiser's office. And then Exhibit B is the copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, and a copy of the signed certified member return receipt.
Can you tell me a little bit of a narrative as to what's going on the property and why this is a violation of LDC 3102E?
Yes, sir. So they have 3 Connex containers on the property, and per that code, they're not allowed the containers.
Are the containers allowed on the property?
No, sir.
Okay. Because I see in this code section, it says vehicles, trailers, manufactured housing, shipping containers shall not be used as storage building, utility building, or other such uses.
Correct.
So is it the county's case that the shipping containers are being used as storage?
2 for storage and 1 for a hurricane shelter.
Okay, and how do you know that?
They had told us, the property owners.
Okay. I wish I had a hurricane shelter like that, but I don't. All right, so you've heard what the county's case is. What I always have the county do, and this is for everyone's benefit, is I'll ask Mr. McGuire to show you what's been proposed as the exhibits, the photos and the notices. Let me know if you have any objection to them being evidence in this hearing, okay?
You can put just a container, this is the front of the house. Okay. Do. Okay, that's the one little one, the new one. Hey, you dashed there, got my pole barn up. Okay, there's one. Okay, that's the back of it, okay.
This is all the mailing.
Mm-hmm. I got most of that. No, I got it.
All right. Thank you. I'm just going to take a moment to look at these just so I understand what the county is proposing or talking about. Just, okay, I see. Oh, okay. So it's just the three that you're talking about, Mr. McGuire?
Yes, sir.
All right, please proceed.
During my initial inspection, myself and JC had met with Mr. Dwight. He had told us that he had the containers on the property. He told us what they were being used for and such. And then throughout, he had came into the building and then had to try to inquire more information about them. And then since then, it leads us to today that they're still on the property.
Is there no permit for them?
For the containers?
Yeah.
No, sir.
Okay. Ms. Katu, do you have anything that you want to say?
So just under 5 acres, 4.9 RURMH, they cannot obtain a permit for the shipping containers. And it's creative with the hurricane shelter, but also you can have a hurricane shelter, you can't use a shipping container as a hurricane shelter. It's the
Well,
shipping container issue.
What I see in the code section 3102 is all accessory uses regardless of location shall be allowed once a permit is issued.
Correct.
So if there are no permits, it doesn't matter what the shipping container is for, correct?
True. Absolutely.
Okay, so I just want to make sure I'm on the same page. Mrs. Broussard, you've heard what the county's case is. Why isn't there a violation?
We never knew that you had to have a permit for a container. I've got a letter from, that says in November 28, 2023, you could get a container with a permit.
Right.
We got them in July of 2023, the two of them. The
Sure.
third one came in 2025.
But I think the key word there was the permit.
Right.
Right? And so the real question to me is, given that it appears to me that the containers, you probably have a good reason for them. I don't dispute that. And we all know in Citrus County, it might be nice to have a hurricane shelter from time to time. But you got to go through the county and get the permits for all these things. So
I agree, but we never knew.
no, fair enough. So my question to you is, how much time do you need? I mean, this case started a few months ago. Have you started the permitting process and everything?
No, I was waiting for this to find out what was going to happen. Will they retroactively give me a permit for the two containers?
Well, let me
Probably
just
not the third.
I want to explain for you and for the benefit of the public. I mean, once you get a notice of violation and they're telling you that you're in violation,
Right.
you got to work to correct the violation. Coming to me and then saying, well, yeah, it's been in violation for an additional 3 months. What makes a difference to me is making an effort to fix it, bring it into compliance with the law. I'm not going to give, let me put it this way, I expect y'all to try and bring it into compliance. So how much time do you think you need to do that?
To apply for a permit?
Yeah.
Or we can do that probably between now and in the next week.
I agree. How long does it take? Or
As Ms. Katu testified, he cannot get a permit for these. They have to be removed.
oh, okay.
And
is that,
his letter-
Initially.
I'm sorry, sir. Hold on a second.
His letter that he referenced was dated 2023.
Right.
Unfortunately, this is a new change in the law that happened, I believe, in 2024, that they can't have Connex boxes, so he cannot get a permit for it. He would have had to have gotten the permit back before the law changed.
So there's no zoning issue. It's a Connex issue? What is the law? I mean, what is that?
That says
So the county changed,
the county commissioners changed the code because Connex boxes in residential areas were seen as a concern. And so I believe, Ms. Katu might have the date for me.
Yeah, he's quoted it correctly, November of 23. I think I actually told him that. But prior to that, to have those on property, you needed a permit for them. So so we don't have any record of a permit, so.
there is no permit. I
Yeah,
mean, there's
so we
none in
can't-
evidence.
So we can't backdate and go get one now, no.
And now that this has changed and the commissioners have changed the code so that they are not allowed in rural residential, he cannot get a permit retroactively after the change in the law. So he has to remove them to cure.
Correct, they were unpermitted in 2023. If that's when he placed them on, I don't know.
I do see that the code section says that shipping containers shall not be used as storage. Why would the hurricane shelter be subject to that?
Our understanding is utility building is any exterior ancillary building outside of the primary residence. So a hurricane shelter would fall under the definition of a utility, the general understanding of what a utility building is, because utility building is not specifically defined in the code. So then we fall back on statutory construction of the general understanding and definition of the term.
Unfortunately, I agree with the county. And so what they're saying is that the county changed the law so to prevent you from having Connex containers in this use. If you had wanted to keep them on the property, you would have had to permit them 2.5 years ago, essentially, before the amendment to the code. And so this would apply, I assume, across all zoning designations or all residential.
Residential.
So in order to assess how you bring this into compliance, Mr. and Mrs. Broussard, it's really not a question of obtaining a permit since that will be foreclosed to you, it sounds like. The question is how much time will you need to remove them?
Since you can't have them in Citrus County, I don't know. We were talking about putting them on Marketplace. The one container that we use as a shelter, it's insulated, it's wired, it's water. That one probably $10,000 if I can sell it. The other one is just 8 by 40 with shelves in it for storage, but it's attached to my pool.
I see.
I have a deck, and the deck is screwed to the side of the container, and screen shelter is attached to the top of the container also. I've got a bid on that to get that fixed.
You do? Okay.
Yeah, I did that long time
That's great.
ago.
Okay.
So I've got 3 containers, and I agree with that, but in my area, there's containers all over the place.
Well, and this comes up a lot at these hearings where people say, you know, look, even if you think my property, wait till you see my neighbor's property, which is true, right? There's a lot of other, this is by and large, a complaint-based system where if people complain against a certain property, it's not the county's responsibility to, on its own, just go out and round everybody up who they think is in violation. It's based on complaints that come in. So, I'm just saying it may be the case that others have these containers and are in violation, or some of them may have gotten the permits in the time. I don't know, but it's not before me today. What I need to do is give you a reasonable amount of time so that, you know, you're not unduly penalized. I do think there's good faith when you initially got them, but I'm probably inclined to give you a couple months to sort this out.
And if we can't sell them on Marketplace?
There will be a fine if you don't get rid of them within whatever time I determine.
Okay, question, if I have an LLC, am I allowed to keep the containers?
It's not a matter of whether it's an LLC or an individual. It's the use of on the property. So your LLC can own the containers and do whatever they want with them. They just can't keep them on the property.
Okay, I've got pictures of businesses nearby my house that have multiple containers.
And that might be a different zoning. I don't know.
It's in town.
But by the way, if you want to introduce something as evidence here, now would be your time. I don't know if it'll be relevant, but I encourage you. I want to give you every opportunity to lay what defense you have.
Okay, these are pictures of all the containers around my house. Trucks.
Could you show them to Mr. McGuire, sir? And thank you. The county will take a look at that. Let me know if they have any objections.
Just as to foundation and relevance.
I think the, what's been proffered is that this is evident, and tell me if I'm wrong, Mr. Broussard, but you're introducing this for the proposition that other people have these, and why not you?
Right.
Yeah. Makes sense?
And again, my, excuse me, the photos don't indicate the addresses. We don't know the zoning for those locations. I understand his position, and if he wants to call in complaints to those addresses and have those individuals be in the same position he is, if their properties don't qualify, the county takes complaints every day of the week. But for his case, we just don't see that it's relevant here.
I'm going to admit it as Exhibit C. I think you have that right. I think it's relevant for your defense. The problem is I don't think it carries the day because, again, it's whether someone else violates something doesn't really bear on your case. They may end up in front of me at some point. I don't know. In any event, what's the county's recommendation?
$100 per day.
I'm going to give you 4 months to bring the property into compliance. If it's not brought into compliance in 4 months, then there'll be a $100 a day fine.
Even if I put them for sale and nobody buys them.
You've got 4 months. You can blow them up, take the trucks, of the components off. You can have someone ship them off. I don't care how they get off myself. I encourage you to comply with the law. Don't use detonations. I'm sorry, don't use illegal detonations. I have to say that. But 4 months. All right? And you can appeal my order. So, all right, good luck.
Thank you.
Next case. David Getchell and Keisha E. Tuponia, case number CE 2025-2312, Code Officer Julie Wilkinson, page 20 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Yes. David Getchell Jr.
Okay. Good morning.
Morning.
All right, good morning.
This is case number 2502312, violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. The address is 7758 North Cricket Drive, Citrus Springs. Property owners David Getchell and Keisha E. Tupoina. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on December 31st, 2025. Photos from a final inspection on February 17th, 2026. An aerial photograph from the Citrus Property Appraiser's website dated June 20th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Can you give me a brief narrative of what's going on the property?
Yeah, so this is a vacant lot that was once wooded, and it has been clear cut and graded.
Okay. Ma'am, and before you show the exhibits, if you would, sir and ma'am, are you contesting whether or not the site has been changed?
No,
Okay.
not at all. No,
Okay.
we loosely contested because we didn't have a good understanding of what we were in violation of and like why it was a violation. So that was really.
I mean, I can help. Does it make sense now, or do you want me to
After
try
hearing
and
some of the other cases?
Yeah,
sure.
yeah. I mean, by the way, this happens a lot. And in some counties, they don't require permits for taking down certain trees or certain grading, but it is the trend in Florida to start requiring that. And
Sure.
the reason is the environmental concerns. The reason is that sometimes, it could be that neighboring parcels are flooded based on the grading you do. In Florida, it happens these days with development. So the county has these laws to protect both yourself and the neighbors, frankly. And so that's why we're here. It doesn't sound like they're contesting that there was some work done. We'll talk about it. What's the county's recommendation? What is the county's recommendation?
It's going to be $5,000.
Okay, what is the size of the parcel? 0.2?
Yes.
0.28.
So a quarter acre. So it's a residential, it's just a vacant residential. Are you building a home there, or are you?
So this property backs up, this extends off of our backyard. We had purchased that land to extend our property. We are also already in the process, and had been prior to receiving any notice, of having those lots reconfigured. We have the site surveys for both of those lots. Unfortunately, we don't have the combined survey yet. It's been done, but he hasn't given me the PDF copy of that yet. So Willis Howell is
You're working on it.
Yes.
Is there anyone from the public who wants to be heard on this case? I don't see anyone. I mean, look, there's good news and bad news. The good news is I'm not going to levy a $5,000 fine. The bad news is I am going to levy a fine. And customarily in these cases, I try to do it equally and fairly. You heard what happened in the other case. That's what I'm going to do here as well.
$2,500 fine.
It's going to be a $2,500 fine.
Okay.
I understand. I just tell your friends, tell anyone else in the situation, get a contractor who does the right thing and gets a permit. I'm trying to spread the word, so any help would be appreciated.
Yeah, understood.
All right, good luck.
Thank you.
Thanks. That's it.
Okay.
Yep.
Thank you.
Next case, Jose Giovanni Galarza Villafane and Sheila Michelle Rodriguez Castro, case number CE 2025-2278. Code Officer Robert DeNaro, page 19 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
This is page 19? Okay.
Yes, ma'am. Jose Villafane.
Sheila Rodriguez.
Okay. Welcome. Thank you. All right. Tell me about this case.
Yes, sir. Robert DeNaro, Citrus County Code Compliance Officer. This is a repeat violation initially observed on December 24, 2025. The address of this violation is 9243 South Florida Avenue, Floral City. Case number CE 2025-02278, Land Development Code, Section 2412, General Commercial District of Citrus County Ordinances. This property is, the property owners are Jose Giovanni Villafane Gazzara, I guess, and Sheila Michelle Rodriguez Castro had previously been found guilty of the same violation at this location on June 30th, 2025. This case number is CE 2025-00370 with 0 imposed fines and administrative costs. The case was abated on October 1st, 2025. Good service posting on property and posting at Lecanto Government Building and signed certified return receipt. I would authenticate the following documents and request that they be admitted into evidence. Exhibit A, finding of facts and the acknowledgement of compliance from previous case, 2025-00370. Exhibit B, photos taken at the initial inspection on the 24th of December, 2025. Photos I took during my subsequent inspections.
Did you say the December 24th?
Yes.
You were out on Christmas Eve taking photos?
Yes, sir. I'm
Okay.
working.
All right.
I'm working hard for the county. Yes, sir.
Is that
So-
you, Mr. Charlton? Where's Charlton? Like he
Yeah.
escaped because I've got some
Yeah,
I've got
'cause-
some questions.
Well,
okay.
because,
All
yeah,
right.
Mom, that's the kind of...
Merry Christmas. All right.
That's the kind of guy he is.
Okay.
Anyway. And photos I took during my subsequent inspections on December 29th, 2025, January 5th, 2026, the 16th of January, 2026, and on those dates, the property was still found in violation. Photos from January 21st, the 27th, February 3rd, and the 9th, and my final inspection yesterday, 17th of 2026, the property has been brought into compliance. Exhibit C, a copy of the repeat notice of violation and hearing sent to Jose Giovanni Villafane Gazzara and Sheila Michelle Rodriguez Castro. A photo of the notice of violation and hearing posted on the property, a copy of the general pre-hearing order, and a copy of the posting affidavit. This property is 1.3 acres and is zoned general commercial district. I conducted an initial inspection on 2024 and observed numerous vehicles stored on the dirt. Somebody calling me?
Do you
Sorry, go
have,
ahead.
do you have evidence to?
Oh, yes. but-
No, well, first, no, let me, I do want to know. I want to,
Yes.
so, I mean, I remember this case.
Yes, okay.
But I want you to
Oh.
tell me just give me a brief narrative
Okay.
as to what's going on.
So basically, it was a repeat, as you were aware. I saw that obviously past where their original site plan was, there was a number of vehicles being, stored on that location, most of which were in disrepair or inoperable. So, and then eventually, like I stated, as of January 21st until my final inspection yesterday, all those cars had been removed and the property had been brought into compliance.
Well, wait, on what date, from your perspective, was the property brought into compliance?
From January 21st.
Oh, okay.
I had received the call from Ms. Castro, and she had stated on the 15th to me that it was brought into compliance. As I initially stated on the 16th, I did go. There were still some vehicles there.
Okay.
So, and then on the following week, I went, because it's a weekly inspection, on the 21st on to yesterday's date, no vehicles were in that designated
So
area.
from your perspective, as of January 21st, the property was brought into compliance.
Yes.
You've got a little less than a month of the
Yes.
property being out of compliance.
Right.
Okay.
Yes, a total of 24 days.
Okay. Then I would ask that you show them your exhibits. We'll talk about what's going on, and let me know if you have objections to these exhibits.
It's a lot of photos, because a lot of weeks. So this was on the 24th. You can see the car. What's that? Oh, okay. Okay, yeah, sorry about it. The dates are on the bottom. Yes, okay, yeah. I just wanted to.
But that's fine.
Thank you.
All right. Thank you. Let me just take a quick look.
Excuse me.
Okay, I think I see what the issue is. It's certainly well documented. I don't have a copy of the other exhibits. I only
Oh.
have a copy of the photos. Well, did you show the exhibits to respondents? All right, now if you would, thank you. Yeah, I just want to take a look at everything. I do remember this. I mean, I thought it was interesting at the time, and I'm just, what's going on?
So the thing is, like I said, we have also like a repair shop in
Yeah.
the front, right? So, sometimes we, when we have a towing company, right? So sometimes we, we park cars in the back and et cetera. But long story short, at least after going through this again, we had the Zoom meeting with the counties, with the zoning department and all that. And we had come to an agreement that as long as we could park vehicles back there, as long as it was overflow from the repair shop. And that was understanding. Anything else from that, then it needs, which of course, maybe for me, doesn't make a lot of sense because all that is the same property, so I don't see why I couldn't use the property to park vehicles. But like I said, I need to go through zoning and some other stuff if I wanted to change the zoning.
My understanding is that the violation here arises because there's a site plan on the site, and they're parking cars where they're not allowed to under an approved site plan.
Perfect, absolutely.
Right.
The preamp, what he's referring to, he was asking about whether they have to be paved in the back, and if it's overflow parking and not required, yes, but that's part of a site plan review. That's why we met with them. We've met with them. I think I've talked to them on the phone as well. It's not that they can't do this use back there, but the site plan doesn't extend back there.
Meaning they have to amend the site plan.
They will have to. They may have to do some stormwater, may not. That's up to
Yeah.
engineering, but may have to do some grading. I don't know, but
It's not necessarily the case that they have to put a parking lot back there, but they have to amend the site plan, and there may be ancillary things that
right,
go
to
along
do any
with
work back past that one point where the concrete ends, they need to amend the site plan and tell us what they're gonna do back there. They can do it, most of it, not a junkyard, but most of that, what
I
they're
mean,
doing.
it looks like to me they can do it. I mean,
Yeah,
I wouldn't see why
absolutely,
not,
but it's
given this.
permit, it needs to be permitted, and it's not at this time.
Makes sense? Okay. Is there anyone from the public who wants to be heard on this case? All right, here comes the bad news. What's the county's recommendation?
Well, the county's recommendation would be for the 24 days at $150 a day, totaling $3,600.
I also have good news and bad news. The good news is that's one of the lowest fines they've ever recommended for a repeat case. I mean, I want you to understand that. I know that it might not seem that way, but that's actually really generous from the county, because normally they come to me and they say $350, $450, because they have an interest in making sure it doesn't happen again. I think you have the plan, though. Like, you know what you have to do it. So instead of rejecting the $150, I'm going to accept it because I believe you're going to go ahead and change it. But I will find that there's a repeat violation. Y'all took care of it before, which is great. I just hope you can do it again and make sure it doesn't happen again. All right, so it will be a $150 a day fine for the days that Mr. Denaro said. Okay? Good luck.
Thank you. Have a good day.
Next case, Alfonso Paulino, case number CE 2025-02211, Code Officer Cody McGuire, page 26 of your agenda.
Yes, I do. Paulino Alfonso.
Good morning.
Good morning. I'm not contesting this. What I came up here for is one reason. I'm going through a lot of personal things right now that I'm dealing with, and I apologize for the mess, but I got it done in 21 days. And I got everything done. The only reason I come up here is to see if the fine could be lowered because of the financial hardship that I'm going through.
I don't know if there is a fine yet, so let's talk to Mr. McGuire. Is the property in compliance?
It is.
It is not.
No, it is.
It is?
Yes, sir.
What do you want me to do?
Well, it's a repeat violation.
I see. Okay. Tell me about so I do have to hear from Mr. McGuire.
Sure.
All right? Tell me what's going on.
It's a repeat junk. Do you want me to go through all the?
Yes, I do.
Okay. So it's a repeat violation of initially observed on December 23rd of 2025. The address is 740 Southwest Bend Point in Lecanto. It is 2.52 acres, and it is zoned LDRMH. The case number is 2025-2211, accumulation of junk and debris. The property owner is Paulino Alfonso. Good service via posting the property and the Lecanto government building. And then I'd like to authenticate the following documents and request to be admitted into evidence. Exhibit A is the findings of facts and an order acknowledging compliance from the previous case number 214-6751, or I'm sorry, 6571. Yes, sir. Exhibit B are the photos taken during my initial inspection on December 23rd, subsequent on the 30th, and then other subsequent inspections on January 7th, the 9th, and my final inspection on the 13th of 2026. And then Exhibit C is a copy of the notice of the repeat violation and hearing sent to Mr. Paulino. The photo of the property posted, general pre-hearing order, and then the posting affidavit.
Just tell me a little bit about what's happening on the property.
So originally, I had received this case for a junk. I had seen the violation from the front. I had then went on vacation, and JC did my subsequent inspection and seen more on the side. I've been in contact with Mr. Paulino throughout the whole thing, and he brought it into compliance.
How long was it out of compliance?
21 days.
All right. What is your recommendation?
$150 a day.
Okay. Can you show the exhibits? And I just want you to know if you have objection to them, because I want to look at them.
Okay, what is it?
So this is all the findings of facts from the previous case. Those are the photos that I took every time I went out.
Okay.
I had expected a lot more cases today, but, okay. I guess you guys are cleaning. I mean, I'll knock on wood. I just thought.
And then this is the verbiage that you had
Yeah,
required.
yeah,
on
I
the
saw
yellow
that.
sign. This is all the verbiage that was on that yellow sign that I posted.
Okay. Thank you.
All right, thank you. I don't hear any objection to the evidence, so let me just take a look at this.
Yeah, I got it done as quickly as I could. I'm going through some really,
I believe you.
I got
Just,
some really bad news.
I believe you. Just give me a moment to review this, because I actually don't remember this case. I usually do remember these cases, but okay, this is rather a little bit older.
Yes, sir.
Mm-hmm. Okay, tell me what's going on. I mean, what is going on? I do want to hear from you.
What happened was I had some deaths in the family that really threw me back and things got out of hand. It was, the last offense was in 21, and it just threw me back, and I've got it all in order now. Everything's nice. Everything's the way it should be. I mean, I was just dealing with some stuff. But everything's now in order. I try to get it done as quickly as
Are there chickens back there?
I could.
Are there chickens? Or
Pardon?
roosters?
I think those are geese, right?
Geese?
The white things in the back, geese or ducks?
You have some
Ducks.
animals? Ducks? Are there ducks? Are there geese? Are there?
I've got chickens and some ducks.
Okay. Good for
Yeah.
you.
Yeah, they're at the side of the lot. The chickens and the ducks are on the side of the lot.
Is there anyone from the public who wants to be heard on this case? County's recommendation was 150?
Yes, sir.
Okay. And what would that come out to at 21 days?
3150, if my math is correct.
Okay. I am gonna find that there's a violation on the property, okay? I will reduce it from 150 a day to 125 a day, but I can't go lower than that. This
That's
is a
fine, sir.
repeat violation,
Everything else, that's fine.
But you realize, here's the flip side to it. If it happens again,
I won't.
it's gonna be 350, 500, something
It
like
won't
that.
happen again, sir.
Okay, in that case, good luck.
Thank you.
Next
Thank you,
case,
sir.
Underwood Residential GC 26 LLC, case number CE 2025-2258. Code Officer Julie Wilkinson, page 29 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Yes, ma'am. Brenda McKenzie.
Good morning.
Good morning.
And you are here in what capacity?
Well, I've spoken with Julie and JC and asked about being an authorized agent, and they said, no, I needed to get a power of attorney from the corporation, and I have both of those with me.
Okay.
I offered them earlier, and she just told me to bring them today.
Well, that's okay. I mean, that's what I needed to know is
Okay.
do you have either a corporate resolution would
Right.
do or power of attorney
Yes.
would do? Could we see a copy of it?
Yes. There you go. You're welcome. Yes, ma'am.
Oh, do they actually cite the case number?
They don't, that's why I asked.
Oh,
Within the context, it cites both cases in both documents.
oh, it's fine by me, yeah.
How does service?
I don't need that.
Okay.
Okay, I don't have any objection from the county. I'm prepared to let you have standing. And yeah, this is certainly sufficient. All right, so, well, okay. Technically, I'll tell you this. Normally, for a power of attorney, you do need to have witnesses, normally. But because this is a company, I kind of think I'm going to accept this as a resolution since it's signed by the manager, and in which case I don't need witnesses. Okay?
Thank
So
you.
I accept it as sufficient, and I would like to hear from Ms. Wilkinson.
Yes. This is case number 250228, a violation of Citrus County Land Development Code, Section 4002. Site development without a development order or permit. The address is 9870 North Lathyrus Terrace in Denellen, Florida.
Actually, first let me ask, Ms. McKenzie, are you guys contesting that there's a violation in either of the cases?
Sort of.
Okay, all right, then go ahead, sorry.
The property owner is Underwood Residential GC 26 LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on December 19th, 2025. Aerials from the Citrus PA dated June 21st, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Well, first of all, Ms. Wilkinson, we're dealing with both cases together, correct? No? Okay. All right, then can you give me a brief narrative of what's happening on this property?
So on this property, it's a vacant lot that was once wooded. It's been clear cut and graded, and no permit was issued at the time that the work was conducted, or at the time that I had done the inspection.
Okay, then can you please share the exhibits? Let me know if you have any objection to them. Are they fraudulent, inauthentic?
No, thank you.
All right, let's just take a brief look. Okay, it's a little surprising. Go ahead.
This property is listed on the property appraiser's website as a vacant lot, 0.23 acres, and is zoned rural residential. I conducted my initial inspection on December 19th and observed that the once wooded lot had been clear cut and graded. While researching the property, I observed there were no permits issued or applied for. As of my final inspection on February 17th, a permit has been issued on December 22nd, 2025. I have not had contact with the property owner, but I have had contact with Ms. McKenzie.
Okay, so my understanding is, from the county's perspective, there was site clearing, it was supposed to be a vacant wooded lot. But since the case started, a permit has been issued and work has begun in earnest pursuant to the permit on the property. Is that correct?
Yes.
Well, I'm just looking at the photos because I don't know what you're showing me, but it appears that on a photo dated yesterday that there's a house being built.
Yes, 'cause
Okay.
they got the permit.
That's what I
yes,
mean. Okay.
yes.
All right. So what's your perspective?
So my name's Brenda McKenzie. I'm with McKenzie Permitting and Consulting. I've been doing the permitting for Underwood for over 12 years. They've been in business here in Citrus County since the 80s for decades and have never, ever had any sort of violation or code enforcement. The permit was applied for. We'd had survey work done, engineered plans, and the permit was ready November 19th. Permit number 2010-0896. And another one, but we'll talk about that one separately. They're notified, hey, your permit's ready. They're like, oh, great, you let your subcontractors know, here's a list of work that's coming. They do about 4 homes a week, bring in over $2 million approximately a year in permit fees and impact fees. It was a gross oversight that they just hadn't picked it up. They would never, ever, they have a very reputable reputation in Citrus County, and I do work for a lot of people. This was definitely not, hey, let's go out there and clear this and get going. It's just, the permit was ready in November. And then in December, when they said they're out there clearing, they're like, oh my God, we didn't pick it up. Immediately picked it up, immediately. And we're like, we can't believe that we didn't. I think it was a case of where all the subcontractors that, keep the guys working, you let them know here's jobs that are coming so they know, and the guy was out there grading. I think it was just a gross oversight that the permit that was sitting there waiting in November just wasn't picked up. And as soon as they knew that, they're like, oh my God, they went out immediately and picked it up and paid the close to $13,000 price and picked up the permit immediately.
I mean, that price was just the price of getting the permit, right?
Yeah. So we'd already paid for surveying, engineering, blueprints, energy calcs, the whole thing that takes to get a permit, and the permit was sitting there waiting.
Yep.
They knew it was ready.
Yep.
And then, the guys have their work orders, and it just slipped through the cracks that it wasn't picked up. So I asking forgiveness on someone that didn't just, hey, let's go out and clear some land and see what it looks like. You can't get a clearing permit in Citrus County. A lot of people want to get a clearing permit so you can check your site. We're apologizing that this happened, and would like for you to know that we did have the permit there approved to do it. It was just a gross oversight that it wasn't picked up.
I believe that. I mean, I believe that based on the amount of time it took to actually pull the permit, and then the work is being done. It looks like good work being done. What's the county's recommendation?
It's going to be $5,000.
Is there anyone from the public who wants to be heard on this? I don't see any. Look, I'm not going to unfairly punish Underwood Residential GC 26 any more than the innocent homeowners who don't know and don't have any reason to know or to follow the processes. I think this is just going to be a valuable lesson for Underwood in making sure that the processes are followed. I mean, it's an age-old story, right? Follow everything on the checklist. So I am going to assess a $2,500 fine and call it a day on the first case.
Thank you.
Next case, Underwood Residential GC 26 LLC, case number 2025-2259. Code Officer Julie Wilkinson, page 30 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
This is case 2502259, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. And the address is 9884 North Lathyrus Terrace in Denellen, Florida. The property owner is Underwood Residential GC 26 LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Photos I took during my initial inspection on December 19th, 2025. Aerials from the Citrus PA dated June 21st, 2025. And photos from a final inspection on February 17th, 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
I assume we're going to have the same discussion.
A little bit.
Oh, little bit.
Little bit.
Another wrinkle. Okay. It's different on this case?
A little bit.
Okay, tell me about it.
Okay, thank you.
We'll admit the exhibits.
Okay.
What's
Do you
going on?
want-
Yeah, I want to know.
Well, it's basically the same thing. We had a permit ready in November. The guys got their orders to start work, got out there ahead of time. As soon as we realized it, picked up the permit. There is no construction going on that one because once we got moving on it, realized it was a difficult site and we had to go to a smaller floor plan. So if it looks like we don't have a permit on it, we have a paid permit for it. I've reapplied for the new floor plan that would fit better, be a better fit for that piece of property and drainage and that type of thing. So if it looks like we don't have a permit on it, we do. It's paid for. A new permit has been applied for. We stopped, not because it was just not a good fit for that piece of property. And we've applied for a new permit number, even though that permit was paid for and issued immediately as well. And I would like to ask if that fine for the $2,500 could be for these two sites that are side by side, since it's the same violation. These lots are 9870 and 9884 Latherus, and the guys jumped out there and started. And as soon as we told them, hey, we got a permit, you're ready to go, they jumped out there. I was wanting to know if there's any way possible if that fine could be inclusive for the two instead of per each lot, since it was really one scenario for these two lots that are side by side. And that one isn't as far along as that, even though we were told we could continue to work since the permits were issued.
The answer is no, and I'll tell you why. There's a couple reasons. First, like I said earlier, it's hard enough for me as it is to put fines on, single families who are just trying to build a dream home and they clear a lot. They don't know whether they think it might be like Marion County, or they might think that, and to force lay people to follow the law and be responsible for the law and get assessed one-time fines, to me, is the hardest thing.
I
when you're
understand.
experts,
Right.
when you have this much experience and the scale of the impact of the case, whether it is actually greater with two lots, to me, there's only one reason why they're not getting a $5,000 fine each lot or greater, and that's that you're here representing them because you have a good reputation, you're representing them ably, and so the only reason they're gonna get a $2,500 fine on each lot is because of you. It will be greater if it ever happens again.
Oh, definitely
Yeah.
will not happen again.
No, but I mean, do you understand my reasoning? You don't have to agree with it. I want you to understand my reasoning.
I understand your reasoning,
yeah.
and I do disagree. And I see the little guy that's, the individual is like, hey, I didn't know. But in this particular case, they did all the right thing. And really they thought they had the permits, or they never.
What if it was 8 lots instead of 2? What if it was 16 lots? Where do I draw the line? I mean, I won't. What I'm going to do is I'm going to assess a fine based on the violations, just like I would any other family. I don't think you get credit for being big. I think it should be a higher fine purely out of the fact that, you're here with your reputation and I believe what you're saying. Are they getting this one-time grace?
So my point is like, some people go out and just start clearing.
And they get a higher fine.
Okay, all right.
They get, I mean, I don't know how many of these you've seen, but every now and then we'll do $5,000 or $7,500 based on the willfulness. This is really about as low as it goes. So again, I would take it and run. Was there anyone from the public? I didn't see anyone. All right, that's it. Thank you.
Thank you.
Next case, Beverly and Zilpha Bender, case number CE 2025-2038, Code Officer Erica Olson, page 7 of your agenda.
Jessica Gill.
Okay, and what case are we here on?
It's for Beverly Bender.
Okay.
I'm her beneficiary. She just passed away on February 6th, and Zilpha has been gone since 2020.
Wow, okay. And so in what capacity are you the heir to Miss Bender?
I was her living caregiver and her friend.
How are you named in a will?
Yes.
I see.
I do not have it with me, though.
Okay, well, for the purposes of the hearing, I'll allow you to have standing, but I would like to hear from the county.
This is just a junk case, sir. It's probably cleaned up by now. It really was just a few items.
It is.
It is.
It is picked up.
I just didn't go out there yesterday. I went out there on Friday to do my final inspection.
Well, I'd still like to see.
Okay, no worries. Erica Olson, Citrus County Code Compliance Officer, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of the Citrus County Code of Ordinances. The address is 3845 South Flamingo Terrace. The property owners Beverly Bender and Zilpha Bender. Good service was achieved via posting the notice of hearing on the property and posting at the Lecanto Government Building. I respectfully request to authenticate the following documents and have them admitted into evidence. Exhibit A, photographs taken during my initial inspection on the 13th of November, 2025. Corrective action inspection on the 9th of December. An additional inspection on the 28th of January, and my final inspection conducted on the 17th of February, 2026. Exhibit B, copies of the notice of violation, notice of hearing, the general pre-hearing order, copy of the notice of hearing posted on the property on the 6th of February, 2026, and a posting affidavit.
I was just curious, do you have the ones from the 6th that you took on February?
The only one from there is just that it was
Just that?
posted since the cops were there. I
Okay.
didn't want to hang around.
Yeah, that was the day she passed, and it was over mulch. There was, you said because there was mulch, a chain, and a 5-gallon bucket.
All right, I just want to see the exhibits.
Sorry.
That's okay. I can deal with it. Thank you. All right, let me just take a look at these. Okay, well, I mean, I'm going to admit these documents as evidence. I mean, I understand what y'all are saying, that it's probably cleaned up, and it doesn't look like a huge case. But would you like to put anything on the record?
Just that it's done, it's cleaned, it's taken care of.
Well, I am going to find that there's a violation based on the evidence, but I'll grant a time to comply. You can go out, do the final inspection. What's the county's recommendation?
$50 a day with
Okay,
administrative
then I'll
fees.
grant 14 days. Should be more than enough, but given that apparently it's already clean. If it's not brought into compliance as ordered, $50 a day?
Yes, sir.
Okay, $50 a day.
Thank
All right,
you.
good luck.
Next case, 10566 East Rabbit Lane LLC, case number CE 2025-2229, Code Officer Robert DeNaro, page 5 of your agenda.
They're afraid of me. Robert DeNaro, Citrus County Code Compliance Officer. Case number 2025-02229, accumulation of junk and debris, violation Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 10566 East Rabbit Lane, Floral City, Florida. Property owner is 10566 East Rabbit Lane, LLC. Good service via posting of the hearing at the property and county and Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during my initial inspection, December 16, 2025, corrective action inspection, January 7, 2026, and my final photos that were taken, my final photo that were taken, inspection that was conducted on February 17, 2026. Exhibit B, copy of the notice of violation, copy of the notice of hearing, copy of general pre-order hearing, a photo of the notice of a posting at the property, and a copy of the posting affidavit. This property is a single-family residence, .35 acres in the zone coastal lakes and residential district. On December 16th, 2025, an initial inspection was conducted, and I observed cardboard boxes, construction materials, along with miscellaneous junk and debris on the property. On the 16th of December, a notice of violation was issued for the accumulation of junk and debris. On January 7, 2026, a corrective action inspection was conducted and the property remained in violation. As of the final inspection on February 17, 2026, the property remains in violation. I've had no contact with owner. Citrus County Code Compliance Division respectfully request the special master assess a fine of $100 a day along with administrative costs to begin at a date deemed sufficient to abate this violation. The amount was selected based on the actions of the property owner once they were advised of the violation. We would like to ask the special master to additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, can I see your proposed exhibits?
Yes, sir.
The exhibits are admitted as evidence without objection. I don't see anyone from the public.
Sorry about that.
Okay. Sure, thank you. No problem. All right, so I'll take a look at this. Okay. Well, it looks like they're making a very half-hearted attempt
Exactly.
to improve it.
Yes, sir.
Well, we can help them. I'll grant them 14 days to abate the violation. If it's not brought as ordered into compliance, it'll be $100 a day.
Yes, sir. Thank you.
Next case, James Cassidy, case number 2025-2035, Code Officer Cody McGuire. Page 11 of your agenda, expert on the case, Land Development Director Joanna Coutu.
All right. Cody McGuire, Citrus County Code Compliance Officer, case number 2025-2035. Fences, hedges, and walls. The address is 3158 North Pompeo Avenue in Christopher, Florida. The property owner is James Cassidy. Good service via posting the property and at the Lecanto Government Building. And then I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during initial inspection on November 14th of 25. Corrective action inspection on December 12th of 25. And photos of my final inspection on February 16th of 26th. And then Exhibit B is going to be the copy of the notice of violations, copy of the notice of hearing, copy of the general pre-hearing order, posting affidavit, and the notice of hearing posted on the property. And then this is just a simple fencing violation case, sir.
And what do you mean by simple fencing violation?
It's the material and the height.
Material and height. And tell me about that.
So I haven't had any contact with the property owner, Mr. Cassidy, but I was able to see the violations on neighbors' properties.
Well, what material is the violation? What's the height violation? I assume it's over 6 feet?
Yes, sir.
Okay.
And then the material is like a wind mesh that just kind of flops in the wind.
And that's
about 4 feet high in the air.
Yes.
It starts?
Yeah.
Okay. All right, interesting. I'll take a look at the photos. I don't see anyone from the public. Of course, if there is someone hiding, you're more than welcome to come forward and make comment. Exhibits A and B are evidence. How big is the property? I'm sorry? 4.6 acres. Looks like a decent property. What's the county's recommendation?
$200 a day.
So in order to abate, they just need to take down the fence or get a proper one?
Correct.
Okay, well, they've been on notice for quite a while, so I'm going to grant 14 days. And if it's not brought into compliance as ordered, $200 a day.
Thank you.
Thank you.
Next case, Kelly Kate, case number 2025-2213, Code Officer Erica Olson, page 13 of your agenda. Expert on the case, Land Development Director Joanna Coutu. Did you want to do them together or no? Separate? Okay.
Erica Olson, Citrus County Code Compliance Officer. This is case number CE 2025-02213, a violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. The address is 12170 West Restview Court in Homosassa. It's approximately 1.58 acres, zone CLR MH, and is vacant. The property owner is Kelly Kate. I have proper service was obtained via signed certified mail return receipt. At this time, I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photographs taken during my initial inspection on December 12th, 2025. My corrective action inspection, January 5th, 2026. My pre-hearing inspection on February 17th, 2026. Also, aerial photographs obtained from the property appraiser. Exhibit B, a copy of the notice of violation, a notice of hearing, general pre-hearing order, and the certified mail return receipt. Exhibit C is the project proposal letter provided by the property owner, Kelly Kate.
Okay, tell me what's going on the property.
So he owns the property next door and has a home on it. This property is vacant. He has taken some trees down. I do think that some of them were damaged from the storm. He did provide a letter from a company that talks about there was a lot of storm damage from the trees. The flora was, it's irreparable and it needs to be taken down.
Okay. The letter hasn't altered your view of the case, however.
I'm going to refer to
Okay.
Joanna.
The letter that he's provided is a great start. I'm sorry, Joanna Coutu, Land Development. What he says is that the majority of the existing flora on the lot was uprooted dead or a state of decline due to exposure and storm damage. It's not saying that the trees that were removed were a result of that. So a modified letter could get there. This is a start, but it's not. I don't know that the trees he removed were truly damaged.
I guess I'd like to see the exhibits.
Yes, sir.
And again, for the record, I don't see anyone from the public. The county, of course, has the burden of proof on these cases. All right.
And the relief on this one, because of the letter, is going to be a little bit different. The county's okay with the one-time fine, or if he gets this an appropriate letter, that would resolve it as well. But we would like a timeline on the deadline for the letter, like within the next 30 days.
Okay, and if I did do that, I would outlaw, well, all right, we'll talk about that if necessary. Exhibits A and B and C are admitted as evidence. I see why the county's concerned. It's a bigger difference than I was expecting, although it's also the time of year on the aerial as well. What more does the county need to see in the letter?
What I was looking for, what we need to have is that the trees that were removed were damaged. They're saying many on the lot were damaged, not doubting that. But I need to know that the ones they removed meet that one exemption where they were all damaged. That's all they removed. I don't know which ones they removed. Did they just stick with the damaged ones? Did they not? That's what I'm looking for.
I mean, when it says majority, to me,
It's a very minor clarification. That's why I'm totally acceptable if you can fix the letter. Absolutely.
okay, what's the county's recommendation?
The county would like to see if we could get the letter admitted within the 30 days, and if not, then the county recommends $3,000 as a one-time fine.
Okay, I will assess, I'll grant 30 days to provide an amended letter that comports with what the county would find acceptable to find that there is no violation. Barring that, there will be a one-time fine of $2,500.
Thank you.
Next case, Kelly Kate, case number 2025-2214, Code Officer Erica Olson, page 12 of your agenda, expert on the case, Land Development Director Joanna Coutu.
This is case number CE 2025 TAC 02214, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102 Echo. The address is 6874 South Mason Creek. It's approximately 0.99 acres, zone CLR MH. Property owner is Kelly Kate. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 12th of December 2025, my corrective action inspection on the 5th of January 2026, and my final inspection conducted on the 17th of February 2026, and a photo of the pictometry dated 11 December 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Okay, what's going on in this one?
He is using a semi-tractor trailer for storage. He has made contact with flood and permitting to get an alternative means for his storage needs. Because the property is in a flood zone, there are different requirements he has to meet.
Is this a neighboring parcel?
Yes, sir.
Okay. And both of these came from complaints?
Yes, sir.
Wow. All right, can I see the exhibits?
Yes.
There's no one from the public here. Thank you. Exhibits A and B are admitted as evidence. I see. All right, what's the county's recommendation?
$100 a day plus administrative costs.
I mean, from your perspective, is the respondent working to abate the violation or taking steps to do so?
There hasn't been anything applied for, but I did talk to Morgan and Flood, and she has spoken with him. She came to talk to me because she saw that there was an open case, but I don't know where he's at in that process. We're kind of playing phone tag.
Right. Well, then I'll grant, I mean, not having any more, I'll grant 60 days to abate the violation, and if it's not brought in compliance as ordered, $100 a day.
Thank you.
Yep.
Next case, Worldwide Alliance LLC, case number 2025-2058, Code Officer Julie Wilkinson, page 31 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Case number 250205A, a violation of Citrus County Land Development Code 4002, site development without a development order or permit. The address is 8150 North Santos Drive in Denellen, Florida. Property owners Worldwide Alliance LLC. I have good service via posting the notice of hearing at the property. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on November 13th, 2025. Photos from a corrective action inspection on December 2nd, 2025. Photos from a final inspection on February 17th, 2026. An aerial photograph from the Citrus County Properties Appraiser website dated June 20th, 2025. And a photo from the final inspection, February 17th, 2026. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Okay, without objection, Exhibits A and B are evidence, and I thank you. What is the narrative?
It was a vacant lot that was once wooded, and it's been clear cut, graded, and fill has been brought in, and there were no permits issued.
Any contact with the owner?
No.
Ms. Katu, anything?
So back in May of 2025, they applied for a permit, never was approved, never issued. The application expired in October. On January 30th of this year, they had turned in an application page, no plans, it's not going anywhere, and there's been no activity since then.
Wow, okay. Are y'all familiar with this owner or applicant? I mean, you know, anything? Okay. What's the county's recommendation?
$5,000.
Yep, so ordered. There was a violation, $5,000 fine.
Thank you.
Christopher David Howard, case number 2025-2276, Code Officer Cody McGuire, page 14 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 2025-2276, excessive growth and accumulation of vegetation. The address is 5385 West Cinnamon Ridge Drive in Lecanto. It's 0.28 acres and it's zoned LDRMH. The property owner is Christopher David Howard, good service via signed certified mail return receipt in the Lecanto Government Building. And I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during an initial inspection on December 22nd, 2025. Corrective action inspection on January 5th, 26th. And then my final inspection on February 16th of 26th. And then Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, and a copy of the signed certified mail return receipt. And this is an overgrown case, sir. For reference, I don't have a ruler, but there's a 6-foot privacy fence and it exceeds that.
Oh, wow, okay. There are no members of the public. I'll admit your proposed exhibits as evidence and take a look. And I'm sorry, any contact with the owner?
No, sir.
Do you think anyone's living there?
I don't think so.
Gosh. All right, what's the county's recommendation?
$200 a day.
10 days, $200 a day.
Thank you.
Next two cases, Carol Ann Cook, case numbers 2025-2046 and 2025-2062, Code Officer Erica Olson, page 15 and 16 of your agenda.
Erica Olson, Citrus County Code Compliance Officer, case number CE 2025-02046, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of the Citrus County Code of Ordinances, and case number CE 2025-02062, unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20, TAC 41 of the Citrus County Code of Ordinances. The address is 4880 South High Ridge Terrace in Homosassa. It's approximately 0.49 acres, zoned RUR-MH. Property owner is Carol Ann Cook. I have good service via signed certified mail return receipt. For both cases, I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during my initial inspection on the 12th of November 2025, corrective action inspection on the 9th of December 2025, and photos of my final inspection conducted on the 13th of February 2026. Exhibit B, a copy of the notices of violation, notices of hearing, a copy of the general pre-hearing order, and a copy of the certified mail return receipt.
So the dates represent the photos for Exhibit A in both cases, correct?
Yes, sir.
And you're going to be giving me different Exhibit As and different
Yes.
Exhibit Bs. Okay. I don't see anyone from the public, and therefore I will admit Exhibits A and B in each case as evidence. Thank you. Any contact with the owner?
I haven't had contact with the owner. On my first or second inspection, there was a gentleman outside, and I talked to him. He kind of waved me off. He didn't give me his name or what his relation was.
Is that the gentleman in the photos on November 12th?
No, there was another gentleman, I believe.
Let's see.
He was just kind of standing there.
I don't know that the problem has gotten better since you've opened the cases.
I don't think it's gotten better.
Yeah. What is your recommendation?
So for both cases, I recommend $150 a day plus admin costs.
Could you actually, I invite you to provide the case narrative. I didn't ask for it, but if you want. I think there needs to be some more detail on the unlicensed vehicle on the record before I issue a ruling.
Okay. On November 12th, 2025, I conducted my initial inspection in response to complaints received regarding junk and unlicensed vehicles on the property. During this inspection, I observed a vehicle with no plate in the driveway. In the driveway underneath the carport, there were boxes, spare wood, filing cabinets, tires, tools, and many other items. A corrective action inspection was conducted on the 9th of December 2025, during which the property was found to remain in a similar condition. As a result, I issued a notice of hearing. A pre-hearing inspection was conducted on the 13th of February 2026, and the property was again observed to be in violation of both ordinances, with no significant corrective action taken for either violation.
Okay. In each case, I find that there's a violation, and in each case, I will grant 10 days to abate the violation. If it's not brought to compliance as ordered, a $150 a day fine.
Thank you.
Next case, James C. and Dorothy V. Kendall Bailey, case number 2026. Code Officer Robert DeNaro, page 21 of your agenda. Man.
Robert DeNaro, Citrus County Code Compliance Officer, case number 2026-0006, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is, pardon me, 8354 South Vine Terrace, Floral City. Property owners are James C. Kendall and Dorothy V. Bailey-Kendall. Good service via posting of notice of hearing at property in the Lecanto building. I would like to authenticate the following documents into evidence. Exhibit A, photos taken from my initial inspection on January 6, 2026, corrective action inspection, photos on January 21st, 2026, and my final inspection photos on February 17, 2026. A copy of and Exhibit B, pardon me. Copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, photo of the notice of hearing posted at the property, and a posting affidavit. This property is a single-family residence, .46 acres, in a zoned medium-density residential district. On January 6, 2026, an initial inspection was conducted, and I observed trash bags, medical devices, along with miscellaneous junk and debris on the property. On January 16, 2026, a corrective action inspection was conducted, and it was concluded that the violation remained in violation. On January, on January 16th, that date also was the date of the violation. On January 21st, 2026, a corrective action inspection was conducted, and the property remained in violation. And as of my final inspection on February 17, 2026, the property remained in violation. I've had no contact with the owner.
Okay. Can I see the exhibits?
Yes, sir.
They will be admitted without objection. There are no members of the public. Thank you. All right, let's take a look at this. We have, yeah, I mean, there's no doubt the photos do, I think, speak for themselves. It's a situation in the front and the back. Is that a backyard or a side yard?
That's the side yard.
Side yard.
Yeah.
Yeah, because it is .46 acres, so that's good.
Yes.
All right, what's the county's recommendation?
County's recommendation is $100 a day, along with administrative costs after the date, and sufficient, after the date you deem sufficient for this violation. This amount was selected on the actions of the property owners once they are advised of the violation. We'd like to ask the special master to additionally find it's the respondent's responsibility to contact the Code Compliance Division when this violation is abated in order to re-inspect.
So ordered. We'll grant 21 days to bring the property into compliance, and if it's not brought in compliance as ordered, $100 a day.
Thank you, sir.
Thank you.
Next case, Corey Matthew Link, case number 2025-2084, Code Officer Cody McGuire, page 22 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 2025-2084, accumulation of junk and debris. The address is 6638 North Bedstro Boulevard in Citrus Springs. It's .46 acres, and it's zoned RUR. The property owner is Corey Matthew Link. Good service signed, certified mail return receipt, and posting at the Canto Government Building. And then I'd like to authenticate the following documents and request they be admitted in evidence. Photos taken during an initial inspection on November 20th of 25, corrective action inspection on December 9th of 25, and my final inspection on February 16th of 26. And Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, and a copy of the signed certified mail receipt. And this is a junkyard condition case with a lot of garbage everywhere.
Okay. What has been proposed as Exhibits A and B is evidence.
I haven't had any contact with Mr. Link at all throughout this. In fact, I believe the property has gotten worse.
It's not the first time that something like that will have happened. The case is a little old. The property does look like it's being lived in. I mean, do you believe the property is being occupied?
Yes, sir.
Yeah, it definitely looks like it's getting worse. Much worse. How big is the property?
0.46 acres.
And there's a dog out there?
There was. No ducks.
Yeah, well, I like dogs too, but you got to watch out. All right, what's the county's recommendation?
That one's $400 a day.
400?
Yes,
Why?
sir. Just from the degree of the debris.
Okay. 14 days to bring the property into compliance and $400 a day if the owner fails.
Thank you.
Thank you.
Next case, Moss Dogs, Inc., case number 2025-2301, Code Officer Robert DeNaro, page 23 of your agenda.
Robert De Niro, Citrus County Code Compliance Officer, case number 2025-02301, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 5120 East Hop Lane, Inverness, Florida. Property owners, Mass Dogs Incorporated. Good service, posting the notice of hearing at the property in Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence.
Let me talk to you about them. So I
Yes.
assume Exhibit A is photos that you've taken on the dates indicated on the
Yes,
photos.
sir.
And Exhibit B will be the notice of violation,
Yes, sir.
notice of hearing, and pre-hearing order.
Yes.
So I would like to take a look at those.
Yes, sir.
And there is no one from the public here to be heard. Again, I invite anyone who wants to be heard to come forward, but you took the photos in Exhibit A? Yes?
Yes, sir.
All right.
Yes, pardon me, I'm sorry.
So this is a junkyard conditions case. I am now looking at the photos. And so now I invite you to give me the narrative. You went out on the property when and what did you see?
Okay, sure. The property is a single-family residence, 0.6 acres, zoned in low-density residential. On December 30th, 2025, an initial inspection was conducted, and I observed piles of garbage, bags, furniture, steel pipes, along with miscellaneous junk and debris on the property. On December 30th, a notice of violation was issued for the accumulation of junk and debris. On January 21st, 2026, a corrective action inspection was conducted and the property remained in violation. Final inspection on February 17th, 2026, and the property still remained in violation. I've had no contact with the owner. County Code, Citrus County Code Compliance Division.
I'll accept that. What's the county's
Oh,
recommendation?
$100 a day.
It appears to me that this is another case where, I mean, your case started a couple months ago, and the problem's definitely not getting better.
No, sir.
Okay. I am going to grant 14 days to bring the property into compliance. If it's not brought into compliance as ordered, $200 a day.
$200 a day. Yes, sir.
Thank you. Next
Thank you.
case, Jason Preet S. Randawa, case number 2025-2200, Code Officer Julie Wilkinson, page 27 of your agenda.
2502200, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 104 South Monroe Street in Beverly Hills. The property owner is Jason Pre S. Rantawa. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on December 10th, 2025. Photos from a corrective action inspection on December 30th, 2025, and photos from my final inspection conducted on February 17th, 2026. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, a copy of the general pre-hearing order, photos of the notice of hearing posted to the property, and a copy of the posting affidavit.
Okay. I don't see anyone from the public. Exhibits A and B are admitted as evidence, and I will take a look to see where this falls on the Becker scale. Let's see.
Becker
Ooh, I mean, it looks like a lot of it is being maintained.
Yeah, the front looks perfect. Then you look at the back.
I mean, are we sure that, yeah, all right.
Were you going to ask if there were shrubs?
Yeah. I mean,
yeah, that's what I thought at first too. I was trying to give an excuse, right? Because I looked for that, but
you don't think
I don't think they're shrubs.
Well, sometimes it's hard to tell the difference with this Florida native landscaping craze because a lot of this stuff doesn't look good, but it's now protected, and not only are a lot of them weeds, but a lot of them are just incredibly ugly. But they're native, so they get preference.
I am by it, I have a degree in ecology, so I can tell the difference between a weed and a shrub.
Okay, well, what's the difference?
Well, first of all, the main definition of a weed is something that's not desired to be
Right.
somewhere, right?
Yeah.
For a shrub, it's going to remain small and it's going to be something that's going to stay a little bit woody. Those are not woody back there.
But there can be things, I mean, we have no idea whether these are desired or not. I mean, you don't desire it. The county doesn't broadly desire it. I mean, I get that. I
At
get
this point,
that.
the only evidence for the special master is that of the county with the
I
photographs.
totally
that
understand.
It does not qualify and it is not protected and is above 18 inches.
There's grass, there is grass back there as well. That is over 18 inches. If
I do see the grass.
Okay.
I do see the grass. All right, what's the county's recommendation?
It's going to be $100 a day.
All right, 14 days, $100 a day.
Thank you.
Thank you.
Next case, Lisa G. Tangwa, John E. Neff, case number 2025-2069. Code Officer Robert DeNaro, page 28 of your agenda.
Oh, man. Robert DeNaro, Citrus County Code Compliance Officer, case number 2025-02069, unlicensed inoperable vehicle violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 8102 East Julia Street, Floral City, Florida. Property owners are Alicia G. Tangway and John E. Neff. Good service. Posting the notice of hearing at the property and Lecanto Government Building. I would like to authenticate the following documents for evidence, into evidence. Exhibit A, photos taken during the initial inspection, November 13th, 2025. A corrective action inspection conducted on December 9th, 2025. And my final inspection photos taken on February 17th, 2025. Exhibit B, a copy of the notice of violation, a copy of notice of hearing, copy of general pre-order, photos of the notice of hearing at the property, and a copy of the posting affidavit. The property has a single-family residence of 0.55 acres, zoned medium-density residential district. On November 13th, 2025, I conducted initial inspection and observed an unlicensed vehicle on the property, unlicensed vehicles on the property. On November 13th, 2025, a notice of violation was issued for unlicensed and inoperable vehicles. On December 9th, I conducted a corrective action and observed one inoperable vehicle on the property and had made contact with the property owner on the initial inspection, who stated the vehicles would be in compliance by the corrective dates. As of my final inspection on February 17, 2026, the property remains in violation. Citrus County Code Compliance Division respectfully request Special Master assess fine of $100 a day per violation, along with administrative costs beginning on a date you deem sufficient to abate this violation. This amount was selected.
Is there only one remaining
Yes. What
issue?
happened?
And it's inoperable, not unlicensed?
Yes. Yeah.
Okay.
It was, on my initial inspection, it was the inoperable vehicle was a little bit difficult to see.
Mhm.
He had parked this unlicensed one in front of it, and then when it was removed,
You saw it.
I saw the inoperable.
All right, well, there's no one here from the public. I'd like to take a look at the exhibits, which will be introduced as Exhibits A and B. They will be evidence in this hearing, and I will take a look here. And is the only contact you had with the owner that one interaction?
No, actually, he was, when I took my inspection photos yesterday, he was outside.
Okay.
And again, like a lot of the public, or we heard earlier, he was stating, what about everyone else? And I
see.
And I indicated we were a complaint-based division, and that, he could be heard in court today. So that was the last I had, I told him I had to excuse myself. I had other inspections to conduct, and that was the end of our conversation
It's
with him.
not a defense. So the inoperable vehicle is this kind of camper thing?
Yeah, the camper, the tires are flat. If you see some
Yeah.
stuff stored inside the,
No, I think you're right.
Yeah.
Okay, I find that there is a violation in this case. I will grant 14 days to abate the violation. If it's not brought into compliance as ordered, a fine of $100 per day.
Thank you, sir.
And I believe that is the last case for today.
Yes,
Is there anything else that Code Compliance wants to take up?
yes.
Okay.
Do you want to address it, JC, or want me to do
Yeah,
it?
I can address it.
Okay.
Well, we had a policy decision on the way we address our violations for 4002.
Oh.
We're doing a notice of violation / notice of hearing. That way, for the type of modifications done, irreparable or irreversible, we can take it straight to a hearing.
So we're coming more into compliance with the statute. We're not giving an opportunity for something to cure it because it's irreparable and irreversible. So this brings it more in line with the statute. So I think you might have seen a couple of them where you see it's an NOV, NOH in one document.
I did see that.
So it wouldn't be, they get an opportunity to get a permit. That's not an option any longer. It's just because it's irreparable and irreversible, it's, here's the amount, the fine amount you have to pay as a one-time fine.
So in the past, when people had come to get a permit, would you drop the case?
Historically, yes.
Okay.
Because we gave them that option on the NOV, that option's no longer gonna be on the NOV, so they'll be on notice moving forward that it's just gonna be a fine.
And if someone does go ahead and get the permit before the hearing, the county will still proceed and ask for whatever it is.
Correct.
Um,
And that can be a mitigating factor that
Right,
Your Honor
okay.
takes into
All right,
account.
then that makes sense to me. Let's see. All right, well, I don't think I have anything else. Is that it?
That's it.
Yes, sir.
All right, the time is 10:57. This hearing is adjourned.
Thank you.
Thank you.